Hello, everybody. Welcome. And you're in for a treat. This is our last free event before the conference. The 26th and 27th is our conference. And we are really glad to bring you such a relevant subject to complement our offerings, which is confidentiality. So all webinars are available on the website together with a summary article for those who are always in a hurry. Yes, some of us have the time to sit in front of the screen for an hour watching it. So our first two in this series discuss the business side of our professional lives. Then we had Professor Mirujia Hernandez talk about how to use our voices as an asset to further our professional presence. And Sue Leschen today will be closing the circuit with her presentation on confidentiality. She's a French interpreter based in Manchester, United Kingdom. I hope I pronounced that correctly.
Yes.
And her specializations are the things we run from, legal and commercial. That's the things I like to work with. She lectures, writes, gives presentations on many subjects that we all need refreshers on, and she'll be talking to you about it in a little while. I just would like to say thank you, Sue, very much for making yourself available, for enriching our professional experiences with your presentation. And we are all familiar with NDAs and contracts and clauses, but Sue is going to help us navigate the maze of words that come with those documents, so that we can feel better at ease by the time we get to the end. Sue, you have the screen. Thank you so much.
Thank you very much, Giovanna, and welcome to everybody attending today. As Giovanna has said, my name is Sue Leschen, and I'm presenting on confidentiality issues and problems for both interpreters and translators. So here is my alter ego, Superwoman. I try very hard to be Superwoman on top of all the other things that I do. I probably fail miserably, but that's whom I aspire to be. But in real life, here is a little bit more about myself. I'm a member of several professional conduct committees of the Institute of Translation and Interpreting, the National Register of Public Service Interpreters, the Regulatory Boards of Sign Language Interpreters. I'm also a member of the Chartered Institute of Linguists Council, which is the governing body of the CIOL. I'm an ordinary member of the Association of Police and Court Interpreters. And all of those organisations are based here in the UK. I am a lawyer linguist. I'm qualified in the UK as a lawyer, specifically as a solicitor. If anybody isn't sure what a solicitor is because you're not based in the UK, I'm happy to explain that later on. My language is French. I interpret and translate both. And I happen to be the director of my very own company, which is called Avocate. For those of you who speak French, Avocate means woman lawyer. And my company specializes in legal and commercial French interpreting and translation services. Increasingly, I'm an independent trainer, mainly in the fields of legal terminology and also other topics of professional interest, such as this confidentiality and perhaps terms and conditions for interpreters and translators. Shockingly, most of us don't have any of our own, but that's another story. I'm also a business mentor, a one-to-one mentor for freelance interpreters and translators who are setting up their own freelance businesses and or developing existing businesses that possibly need a bit of a revamp. But I will say more about that later on for any of those of you who are interested in signing up for sessions. So on to confidentiality. Good place to start is usually definitions. The Oxford English Dictionary definition says that confidentiality means intended to be private or secret. I looked for definitions of confidentiality in our professional codes of conduct, and the two main professional organisations for interpreters and translators here in the UK, certainly the largest organisations, are the Chartered Institute of Linguists and the Institute of Translation and Interpreting. And neither of those codes actually provided definitions as such, although both of them obviously refer to confidential information in various parts of the codes. The ITI code refers to something called privileged information, of more of which I will be mentioning later on. I should also mention at this point that questions can be taken at the end of this webinar. I feel that if we have them intermittently whilst I'm presenting, that we'll probably never get to the end, because there's quite a lot of important information coming your way. So confidentiality is an important aspect. It reflects the trust in a relationship. What do our professional codes of conduct actually say about confidentiality? And again, I looked at the CIOL and the ITI codes for some kind of information about this. The CIOL code at 6.1 says that we should take, or members should take, responsibility for work even where part or all of it is subcontracted. And I think this is quite a difficult ask. I'd be interested to hear what others of you think, because it basically suggests that you are going to be responsible for whatever it is that your subcontractors do, even if you haven't possibly condoned it, even if possibly at the time that they were doing it, you don't actually know what they've done. Many of us do subcontract, for example, translation work to colleagues. Unfortunately, an awful lot of us tend to do it. I'm not including myself, by the way, in this. Tend to do it without either client's knowledge or permission, but that's another story. The CIOL Code of Conduct at clause 6.7 states that we should meet all relevant legal obligations due to the agency, in other words, the language service provider that's booked us, and or employer, if of course you possibly work in-house. And very often your legal obligations in that sense will relate to confidentiality. So, you know, you definitely need to check out not only our own codes of conduct in terms of confidentiality, but what other obligations do we have in respect of confidentiality? And we certainly will have them if you check out the small print in the agency or employer's terms and conditions, generally, which we will of course have been asked to sign. Here again, I sometimes worry myself sick, because I know that many colleagues will just sign anything that's put in front of them in order to access work without actually reading terms and conditions as such. CIOL Code of Conduct at clause 6.8 states that we should comply with any other codes of conduct we are bound by as members of other professional bodies, or by any such code imposed by the employer. And I think that's a really important ask, in that most of us tend to be members of not one professional organisation, but actually of several, which is one of the reasons that I highlighted those organisations earlier that I'm a member of. You know, it's always the case that we are members not only of our professional interpreter and or translator organizations, but, you know, depending on our specialisms, for example, obviously mine is legal, you know, we may be members of other professional bodies. For example, in the UK, many lawyer linguists are also members of the Law Society, which is the governing body for solicitors. If you happen to have specialism perhaps in, I don't know, surveying or along those lines, you perhaps may be a, you know, past surveyor yourself and you're now translating in that industry, you may also be a member of the Chartered Institute of Surveyors. So you need to check out what their codes of conduct say about confidentiality as well. So CIOL Clause 6.4 states that we should disclose any actual or potential conflicts of interest or other factors that may make it inappropriate to carry out a specific piece of work or any other circumstances that might affect the standard of work. And this is a very general clause, clearly, isn't it? But, for example, talking confidentiality now, the subject matter of the presentation, it may be the case that you already are party to confidential information because of a previous job, and it may not be very ethical for you to take on another job knowing what you do know. I mean, that's certainly happened to me. And if you think, you know, there's even the slightest hint of a potential conflict of interest, possibly with a client's competitor or, you know, something like that, you need to stay well clear. One way around it can be, of course, sometimes to notify the potential client that you might have a potential conflict of interest. But of course, if you go into too much detail, then you're probably breaching confidentiality. So if you're in that kind of arena, again, it's best to stay out. Clause 8.1 of the CIOL Code states that we should comply with all statutory requirements and keep all records required by official agencies. Yes, of course, we should be law-abiding. We should be complying with statutory requirements, particularly about, for example, data protection, more of which I'm going to be talking about later. But I think there's a question that needs asking here. If we're keeping records, you know, certainly required by official agencies, however you interpret that subclause, you know, are we talking about the tax office or are we talking about you know, just perhaps corporate clients, we are possibly breaching confidentiality of the client in terms of where we might be storing it. You know, so again, lots of questions around that kind of clause. Clause 8.3 of the CIOL Code states that we shouldn't accept or carry out work if we're aware that it may expose us to criminal prosecution or civil liability, or where there's a duty of disclosure to an official agency. This could be the case where, you know, perhaps you're working on documents for a government department, you know, where you might be forced to disclose your involvement at some point, who knows, by the police or by the fraud office or whatever, you know, and you could find yourself in serious trouble were you to disclose. I am going to go into this further on in the presentation in more detail, but you just have to be aware that you should be very careful when you're taking on work, particularly from non-corporate clients. I mean, I've been approached on occasion by clients who probably are criminals, you know, and they've asked me to translate all sorts of detail about all sorts of procedures they've been involved in, you know, to possibly money laundering, false documentation, this kind of thing. And the minute I've obviously seen where we're going, you know, I've decided to bail out. Clause 8.2 of the CIOL Code states that practicing professional linguists such as ourselves are recommended. It's not obligatory, it's recommended to have professional indemnity insurance. And this is just so important. I cannot stress it enough. If you're on the end of a complaint from a client about breaching confidentiality, whether you're an interpreter or a translator, you're going to need all the help you can get, believe you me. I think that you need to sign up right now to a professional, a company offering specialized professional indemnity insurance to interpreters and translators. If anybody needs the names, I can give you at least a couple of names of relevant companies operating here in the UK, and you can check them out and you know, see what's on offer. They really are worth joining because you just never know the day. I mean, I personally, thank goodness, have never been on the end of such a complaint, but I know colleagues who have, and I sit on professional conduct committees regularly in this line of work, so I know that clients do complain, and also colleagues can complain about other colleagues. Don't forget that. Colleagues could allege, you know, perhaps if they've been working on a joint translation project, or they are partner interpreters on an interpreting assignment, there's nothing to stop them complaining about their colleagues breaching confidentiality, or at least alleging that they've breached confidentiality. So you certainly need insurance in that event. Clause 6.5 of the CIOL Code of Conduct states that we should take all reasonable precautions to keep clients or employers' information and material confidential and secure. Now, I don't know where you work. Are you working in a home office like a lot of us do? If so, that's probably pretty okay. But on the other hand, where are you leaving your work? Are you leaving it out on the desk? Who can see it? Your husband, maybe, your children, your domestic cleaner, if you're lucky enough to have one, any visitors to the house. The situation becomes even more worrying if you are working in a co-working space. Very common here now in the UK. Either you know, hot desk it, you just book a desk for an afternoon, or you know, book perhaps a week in a co-shared office. All sorts of people are in and out of these offices all the time. One of my colleagues who's recently signed up for such a space tells me that she does put all her stuff in a locker, but that for large portions of the day, all sorts of people are crossing the office, looking over her shoulder. They can hear what she's saying on the phone. They can hear her Skype calls with me. She's actually one of my mentorees, I should say. And I find this deeply worrying, actually. So please be aware of those kind of situations. Obviously, where disclosure is required by law, for example, you're aware of perhaps child abuse, or you know, fraud in terms of tax evasion or something like that, you know, different rules apply. And again, we will be talking a bit more about that later. And again, this requirement applies to part or the whole of jobs which you've subcontracted out to colleagues. So again, you know, if you're subcontracting or delegating work of any sort, you know, you need again to reflect seriously on the degree of responsibility you're taking on for them. Disclosure required by law. I really like this slide because it reflects a lot of the interpreting scenarios that I've personally been involved in. And this sort of scenario happens with depressing frequency, where the client will say to the interpreter, "Oh, thank you. It's been such a relief to be able to speak freely." And the interpreter says, "I won't ever tell anybody what you've shared with me." And of course, no interpreter can promise this sort of thing. You may well be required to disclose information. and I'm going to go on a little bit more about that later. CIOL Clause 6.6 of the Code states that we shouldn't use information acquired in the course of work in order to gain unfair advantage. For example, financial advantage, material advantage, career advantage. You know, that information that we've been party to is confidential, not just for the duration of the job, actually, but for all time. So, you know, if we're caught benefiting from, you know, its use, we could be in serious trouble. General Principles and Confidentiality, Clause 7.1 of the CIOL Code, tells us that we mustn't act in any way that might bring individual professional colleagues, the CIOL and/or the language professions as a whole, into disrepute. So remember, if you mess up and you breach confidentiality, especially if that error becomes very public, you know, it's made known either through disciplinary channels or you know, even through the criminal courts, worst case scenario, you know, you have not only dragged yourself into the mud, but you've brought your whole profession down into the mud as well. Do think collegially. Clause 7.2 of the CIOL Code states that we should show courtesy, honesty and integrity in our dealings with our fellow language professionals and with staff, with officers of the CIOL and with other professionals with whom we have dealings with in the course of our work. So, you know, if we know that we have confidentiality restrictions on our work, we need to be very, very sure that we don't breach them. Here's the old water cooler scenario. We stand around water cooler or similar and chat. Interpreters are particularly chatty people, I know, because I am one myself, and we love nothing better than to talk. But even the most innocuous conversation with you know, fellow interpreters, such as, oh, did you hear so-and-so isn't working next week because her marriage is broken up, or because the client got rid of her because she wasn't good enough, or whatever. You know, those kind of conversations are dangerous and can escalate thanks to social media all over Europe and beyond. You know, worst case scenario, be careful. Clause 7.4 of the CIOL Code states that we should be contributing to a professional community of practice. And that professional community of practice means that we share information, obviously, and that information can be about training events, it can be about initial training, not just, you know, continuous professional development, but initial training, how to get into the professions of interpreter and translator. It can be about specialist subject areas. For example, if your specialism is about beauty and cosmetics or whatever it happens to be. But we also have to be very careful that in sharing information, that we're sharing non-confidential information. You know, for example, if we've been told by a client not to share information with our partner translator or partner interpreter about how much we are getting paid for the job, then we mustn't share it, however much, you know, our partner interpreter or translator begs us to do so. Those kind of situations are quite rife. They're not nice to be in, but sometimes language service providers prefer to operate like that. Moving on to the ITI, the Institute of Translation and Interpreting Code of Professional Conduct. Some clauses here that I think we should have a look at. Principle 3 of the ITI Code is entitled Client Confidentiality and Trust. Do have a look at that. What it actually says is that we should maintain complete confidentiality at all times. Look at that again, at all times. Not just when we get the job instructions, not just whilst we're doing the job, but at all times, even when we've handed the job in or we've finished the interpreting assignment. It's confidential for all time. And we should treat all information obtained in the course of our work as privileged information. Do you remember earlier on I mentioned this phrase, privileged information, which must not be communicated to any third party. And all of those assisting us in our work are similarly bound. And that's another subclause reflecting that we are responsible for any colleagues to whom we've subcontracted and or delegated work. I'm going to talk a bit more about privileged information in a minute. Question for you. Be interested to know what you think. Should we ask anyone to whom we subcontract and or delegate work to sign a non-disclosure agreement, an NDA, with us? Obviously, clients, language service providers, agencies, and also individual direct clients may well ask us to sign their NDAs. They may allow us to use subcontractors. They may want to know who the subcontractors are. They may not. They may just simply permit us to use them. But if that's the situation and we are authorised to use subcontractors to delegate work to them, should we be exchanging some useful contract documentation like an NDA with them? Because we may well be completely au fait and with confidentiality requirements and respect them, but do our subcontractors know about them? Are they even members of professional organisations? How au fait with confidentiality requirements are they? I think this is something that we need to explore with them before we take them on. So the ITI Principle 3 on confidentiality states that no member shall disclose what they call privileged information about other members. So, basically I think what the ITI are doing here is using privileged information as a term, as a synonym, if you like, for confidentiality. That's my understanding anyway. But I'd be interested in your views on that. And as I've mentioned earlier, I do want to mention a little bit about what I think privileged information means, how I interpret privileged information. The ITI Principle 3 on client confidentiality and trust refers to privileged information. But to me, privileged information is that information which is shared between a lawyer and the lawyer's client. That's what we call legal privilege. And an interesting question that nobody really seems to know the answer to is, does that legal privilege, where it's the bridge, if you like, connecting the solicitor and the client in terms of confidentiality as regards their consultations and their discussions, does that also bind and cover any interpreters and translators who work with them? Of course, we're bound as interpreters and translators by our various codes of conduct as members of our own professional organisations. But say I'm interpreting in a police station or in a law centre or in a solicitor's office, something like that, and I'm party to obviously confidential discussions between the solicitor and the client. I know for a fact I'm bound by confidentiality provisions imposed on me by my codes of practice. I'm also bound by codes of conduct which I've probably signed up to, where I've been booked by an agency or a direct client possibly, but I'm unsure as to whether or not the solicitor's legal privilege binding the solicitor and the client cover me as well. You can be in situations where you come out of interpreting assignments and somebody will say to you, as did recently, actually only last week, I came out of one appointment on a mental health ward we were just about to go into a mental health review tribunal hearing, and one of the psychiatrists asked me what had just been discussed with the solicitor and the patient on the ward, and I pleaded confidentiality, and he said to me, "But you're not covered by their legal privilege." So interesting area. Confidentiality disclaimers on our email footers. I'm not sure how many of you have got those. If you haven't got any, it might be a good idea, because emails, as we all know, don't always end up in the inbox of the intended recipient. Maybe somebody presses the wrong button, or somebody else happens, it can access the recipient's inbox for whatever reason, maybe legally or otherwise. But we really need wording to the effect of if our email is received by somebody who's not the intended recipient, that they are instructed to delete it and destroy it, not to copy it, and certainly not to distribute it in any way at all, and not to disclose it other than to the sender, in other words, ourselves. Talking about confidentiality duties, as we have been, we need to ask a really important question. To whom is the duty owed? To the client? To the client's client? To other members of one's professional organisation? To colleagues in general? To anyone bound by a non-disclosure agreement? I think all of those are pretty obvious yes answers. I think the client's client might be a little bit of a grey area, because say the agency asks me to, or instructs me to do a translation on behalf of their client, that's the person or the organisation that we call the end client. To what extent, if I breach confidentiality, does the client's client, the end client, have grounds for a complaint against me, or could they sue me? Probably not, but interesting question. To what does the duty apply now? Well, all of these: business data and practices of the client. Those are, again, of the end client, the client's client, a bit of a grey area, as we've said. To all interpreted words and figures, all translated words and figures, all transcribed words and figures, for those of you who, like myself, from time to time transcribe tapes. You may well get NDAs and terms and conditions imposed on you by clients in terms of confidentiality, where there are perhaps specific clauses relating to certain data, for example, and not other data. If that's the case, you really need to pay attention. Which physical places does the duty of confidentiality apply to? Well, any venue that we're working in is the answer to that one. Our home office, co-shared offices, employer's office, other work venues. We are what I think is commonly called in the press digital nomads. A lot of us. We're not just working anywhere obvious like offices. We're working wherever we work, police stations, courts, conference halls, hotels, those of us who go out interpreting. But we're also working, whether or not we're interpreters or translators, in other venues en route to wherever we happen to be going for work purposes or otherwise. We're working in airports, train stations, on trains and planes. How often do we hear people on trains bring up that really irritating phrase when they're talking to somebody on their mobile or their cell phone? If you're in America, I'm phoning from the train, and I think, oh no, I don't want to know. I just don't want to hear, because you just know you're going to hear loads of confidential information. Solicitors are particularly bad at relating the entire, court hearing that they've just attended. I hear that quite regularly. It's just absolutely shocking. Coffee shops, I mention this because a lot of us do need to get out of our offices, and certainly if we're working in splendid isolation behind computers, and we need to go and top up on caffeine and just see human beings from time to time, don't we? And you know, working in coffee shops is increasingly sort of replacement for offices. I know some colleagues who actually work in internet cafes, you know, every single day of the week. You know, it wasn't just J.K. Rowling who worked in a coffee shop because she couldn't afford to pay the electric bill at home. It's us too. But if we're doing that, my favourite, by the way, is Caffè Nero. I just absolutely love Caffè Nero coffee. You know, we're obviously linking up to their Wi-Fi. So, you know, we're not only drinking lovely coffee, we may well be spreading lots of lovely information all around us. Not just in terms of shared Wi-Fi, but in terms of other coffee drinkers sitting near us, listening to us if we're having Skype conversations, maybe looking over our shoulder. You know, when, for example, I'm on trains and I'm tapping away on my laptop, I'm always super careful about getting a seat, you know, where there's nobody behind me. You know, I'm right at the back of the train against the wall, that kind of thing, because being overlooked is bad news. If you take your laptop to the pub, I mean, perhaps some of you do, and it gets stolen, what on earth is likely to happen? Well, this may sound a bit facetious, but this situation actually happened to a colleague in the UK, and it was all over our you know, e-networking groups, because the translator in question was pretty concerned, obviously, and sought our advice. And this incident actually highlights the need for secure storage of laptops, USB sticks, and of course mobile phones. We need to be very particular in terms of ensuring any of these items, any of this equipment, and not only that, but also the information that's stored on them, because that's obviously much more valuable. You know, if I lose my phone, it's not the loss of the actual phone that's going to worry me. It's all the you know, the contact numbers and, you know, all my emails and everything else that's on it, including translation memories on our laptops, all that kind of thing. We should be looking into more and more remote tracking devices. I know fingerprint and iris recognition is coming in big time, and encryption generally. But please be very careful when you take your laptops out of secure areas. I'm just horrified, you know, when I'm out interpreting and I see colleagues just abandoning laptops and laptop bags all over waiting rooms and leaving them. And, you know, it's just terrible. Even on public transport, you know, trains and so on, I see colleagues leaving bags and going off to the toilet and so on. Even in our own professional conferences, I see colleagues happily leaving work bags and going off into other rooms and so on. You know, many of the work bags will obviously contain laptops, many will contain sticks and so on with clients' information on them. It's a no-no. What if the client requires us to destroy confidential information once we've completed an assignment? This is a big bugbear, this one. This affects a lot of us. In my experience, clients actually haven't thought this one through at all. When I start explaining to them, well, okay, if I was to destroy that information, I would have to take on an awful lot of time to make sure that I destroyed my contacts about this particular job all over the show, and I'm going to talk a little bit about that in a minute. But clients just simply impose these kind of requirements on us, and they have not even considered what they're asking us. Obviously, the big one is, okay, if we agree to do it, what about the future? What if the job comes back to haunt us, as obviously some jobs do, and we've destroyed all our so-called evidence? What do we do then? The evidence might be written in terms of, you know, it's perhaps a translator's note explaining why we did X, Y, and Z. It could be oral, it could be on one of the client's audio cassettes. It's a particular way that we interpreted a particular phrase. What are we going to do in terms of our professional indemnity insurers when they're saying, well, okay, I understand you've had this complaint made against you about this particular job. Can you provide us with all the evidence? Many of us, if a complaint comes in, would want to get a trusted colleague to give a second opinion, for example, on an allegedly poor translation. What if we can't do that because we've deleted it from all of our memories and so on? Worrying. So if the client does ask us, or in my experience tries to insist that we destroy all confidential information relating to this job, we need to make the client aware of the following. This will include emails sent and received between ourselves and the client, and or a third party possibly. Any glossaries, translation memories that we've compiled, that we've stored on our PC, or, you know, even in paper format. A lot of us have both types of format. Any requests to professional networking e-groups or other colleagues for assistance with terminology. We may have gone outside of the profession where it's a specialist subject. You know, I, for example, may well have contacted other lawyers about the meaning of, you know, particular words and phrases in a contract. If it's a little bit, you know, outside of my specialist area. For example, I recently had to translate some Scottish probate documents. I was brought up in the system in England and Wales, and Scottish law is you know, is not an area of law that I've actually studied or have much experience in. So I was able to collaborate with a Scottish language professional with the client's permission. And so, you know, as you can imagine, we had a lot of interesting email correspondence going between us. I was explaining the English and Welsh system to her. She was explaining the Scottish equivalents where there were them to me. So there were a lot of footprints there. Also, many of us will consult online terminology sites, you know, just for the sake of argument, Lingy, Google Translate, and well, I hope not, but many others. So, you know, our footprints are all over those as well. Just a little note about Google Translate. A lot of people don't realize, not just language professionals, but people in general don't realize the following. If you look at the site, you will see this message from Google. Google Translate, I should say. Google and those we work with have a license to use, host, store, reproduce, modify, create derivative works, such as those resulting from translations, ... communicate, publicly display and distribute such content. In other words, to cut to the chase, Google Translate can use parts, some or all even, of translations that we have provided them with on other translations. That's the permission we're giving them. So if that isn't breaching our client's confidentiality, I don't know what is. I don't think clients are aware of this at all. It's very unlikely, obviously, that clients supplying confidential information to us would consent if they did know. Perhaps, you know, this is a question for you. We have a moral duty to make clients aware if we are intending to use such terminology assistance. Over to you on that one. Be interested to know what you think. Now to the 2018 Global Data Protection Regulations. These are coming into force obviously next year. I think it's around May, and they will impose significant fines on breaches of confidentiality relating to data protection in order to protect our customers. I think we need to ask ourselves, back to the breach of confidentiality in terms of sharing information, can this actually ever be achieved? I mean, I've talked to a lot of forensic experts, particularly when I've worked, interpreting and translating for the police, and they've actually said the answer to that is no. You'd actually have to smash up your computer in order to actually achieve that. Most of these forensic experts are able to retrieve deleted data from any computer they're given if you give them long enough. It doesn't matter if they're password protected, whatever, they can still get into them eventually. Be careful where you store your PCs and other similar equipment that's no longer in use. I mean, don't throw them in the bin, obviously. Don't take them to the local authority tip. You never know, or the charity shop or wherever. You never know who might inherit it. Non-disclosure agreements, NDAs, we've mentioned a little bit about these, but I wanted to give you a little bit more information because I think this is really important. The usual sort of terms that I see in the ones that clients try and impose on me, and I use that word try to impose on me because I do very much believe in trying to negotiate terms and conditions with clients. The whole situation out there, as far as I'm concerned, is too one-sided. I do actually provide webinar guidance on terms and conditions for anybody who's interested in taking that further. But the usual kind of terms that clients try and impose on us are not to disclose the amount of the rate that we're being paid for the job, either to the client that we're working with and or to our partner colleague. I've already mentioned that one. Not to disclose clients' information unless expressly permitted or instructed to do so, and only if disclosure is not unlawful or infringes the rights of any third party. Not to gain commercial advantages by using information acquired during or as a result of the job, perhaps using trade secrets, for example. And this instruction about keeping all of our clients' materials in secure conditions, for example, not to leave them unattended in vehicles or otherwise unprotected. I don't know how you police all of those, but I think we need to police ourselves and each other as colleagues, to be honest. Still on NDAs, another usual term, to ensure that any person to whom information is disclosed in relation to this particular NDA is fully aware in advance of their obligations under this agreement. And then this again is one of those catch-all clauses whereby they're asking us to make sure, the client's asking us to make sure that anybody we subcontract to or delegate to is similarly covered. So in those kind of situations, it seems to me that we either have to draft our own NDAs for our subcontractors, or should we go to the client and say, well, okay, can you provide me with a subcontractor NDA agreement that I can supply to my subcontractor? Because it also strikes me that if we, draft our own NDAs for our clients, if we're able to, I mean, is the client going to agree with the content of such an agreement if they've never seen it, and they may even not know about it? So I think if we do draft our own, at the very least, we need to, before we send them to our subcontractor, we need to supply them to the client for the client's consent and approval. Onto the Official Secrets Act 1911 in England and Wales. If you're not in England and Wales, and I appreciate that I keep rambling on about England and Wales because I'm based here, but obviously a lot of you may well be elsewhere, but I'm sure in your countries you will have similar laws. This Act is concerned with sensitive information linked to safeguarding state secrets, and it is a lifelong duty. If you're asked to sign the Official Secrets Act here in England and Wales as an interpreter, I believe that the Metropolitan Police in London require their interpreters to sign it, for example. You know, what a lot of colleagues don't realise is that it's a lifelong duty. It's not just whilst you're working for for example, the Metropolitan Police that you're bound. Even if you stop working for them, you're still bound 10 years later as regards any confidential information you came across as a result of working with them. Of course, not all jobs are compatible with being an interpreter. I know many colleagues who aren't, in inverted commas, just interpreters. They have other jobs as well, some relevant, some not. This is a particularly worrying scenario where an interpreter, he was actually a Ukrainian interpreter, Alex Manfunchak, was also, believe it or not, a journalist with one of the red tops, shall we say, the less academic newspapers, if I may put it like that, in the UK. And he was involved in all sorts of scoops and whatever for that newspaper. So, you know, it may well be the case that if we have other jobs that, you know, and we're working for government departments and the police and so on, we may well have a duty to disclose those other lines of work, just in case. Data Protection Act 1988 in England and Wales controls use by organisations of personal information about their members. And I'm turning the coin over now, if you like, to not our obligations as interpreters and translators, but the obligations of our professional associations towards us. Personal means any recorded information which identifies us as individuals, and this can include economic information, social information, cultural information. You know, how often are we asked on forms to declare if we're white, I don't know, transgender, British nationals, or whatever we might be. It just goes on and on. I just keep feeling like I just want to tick boxes that say go away or something like that, but all this information is apparently necessary. But anyway, organisations should only keep information which is fair, lawful, adequate, relevant, accurate, certainly up to date, and not excessive. And it has to be kept, as we have to keep our information in terms of our clients, safely and securely, and it can only be kept for as long as necessary. I suggest to you that a lot of those asks are open to interpretation. Hopefully there'll be more guidance on all of those in future. But we as members do have the right to request to correct, to rectify, to block, and to erase any wrong information that we become aware of. These professional organisations are not allowed to keep information, personal information about us outside of the European Economic Area if to do so would mean that it would be unprotected. We do have the right to make what are called subject access requests about any information that we may want to know about. But of course, as with all legislation, exceptions apply, and that would be too detailed an area for me to go into now, but anybody interested can talk to me about this afterwards. In other words, it's not necessarily the case that the organisation has to comply with revealing information about us for one reason or another. In May, as I've mentioned, I think it's May 2018 next year, the General Data Protection Regulation, GDPR, will apply. Amazingly, despite Brexit, which seems to be certainly heading our way in the UK. I don't know about where you are, but we're certainly getting it over here. Additional requirements to the DPA, Data Protection Act 1988. A lot of emphasis now on accountability. Organisations, professional organisations must have adequate systems. Any complaints can be made to the Information Commissioner. The client's consent is needed to use the data. I'm not quite sure at the moment how that's going to be sought, or how does the client know to give consent if anything is happening as regards his or her data, or our data, it really is. How do we know it's actually being used at any particular time? Unless we've signed an instruction to that effect with our professional organisation, of course. Contracts have to be put into place with clients to ensure compliance with GDPR. And as I've mentioned, that there are significant fines for breach of GDPR. But we really have to wait until next year to see what happens on that score. Confidentiality and exceptions. I did mention this earlier in terms of exceptions to complying with legal requirements as to confidentiality. This one probably affects interpreters more than translators, but this is where we've got reasonable grounds for belief as to actual or potential abuse of children and the elderly, and situations where a client will kill, or has said to us and others that they intend to kill themselves, and or harm himself or herself and others. We as interpreters can see and hear things on home visits and so on that can make us very, very concerned. I've interpreted in homes where children have been there with drug addicted parents. I've been in homes where social services have taken the children away, the children of the family away, and taken them into care. And then I've seen other children in the house who shouldn't be there, and perhaps in another room that the social worker hasn't seen. That kind of thing. What do I do? Do I bring it up? Do I not bring it up? I bring it up basically if I think there is a potential for those children to be similarly abused. How long should the duty of confidentiality last? Well, we've said in terms of the Official Secrets Act, basically forever if you have to sign an act like that. We perhaps need to get clients clarification in their NDAs, possibly. Are they saying this duty lasts for months or for years in relation to particular work? What about restraint of trade clauses that agencies and clients might tend to try to impose on us? Because there has to be a reasonableness criteria. If a client is saying sometimes that this information has to rest confidential for the next 50 years or so on, and the client doesn't want you to work with their competitor in case you breach confidentiality, and that way they don't want you to do that for the next 20 years. Query reasonable, is that a reasonable instruction or not? I think each case is going to have to be decided on its particular merits. Sanctions for the breach of duty of confidentiality. Well, obviously our professional organisations do have them. I know they have them because I sit on professional conduct committees, but basically professional organisations can warn colleagues, suspend them if it's particularly serious. If it's very, very serious, expel them from membership. Some of our professional organisations in the UK are now naming names openly on decision outcome pages of our regulatory bodies, so all and sundry can see. The language service providers, certainly in the UK, are increasingly invoking financial penalties against us. For example, if a translation is late, or if an interpreter doesn't arrive at the appointed hour, that kind of thing. So it's very possible for breaches of confidentiality. They might be looking in that direction as well. But the bottom line is breaches of duty of confidentiality mean that mud sticks, damage not only to individual translators and interpreters, but to the profession as a whole. How do we protect ourselves in advance? Well, a bit of general advice, as best we can, really, is the answer. It's not easy. Obviously, we've talked about professional indemnity insurance, but I would also like to add, if you're working in an area as a translator or interpreter where you've got some pretty high-level sensitive information, it might be chemical formulae, it might be other trade secrets about competitors, processes, it might be government information. I've worked on some serious fraud office cases where I've been transcribing taped phone conversations, where people carriers, I don't mean cars, I mean gangs, are setting up deals to move illegal immigrants around countries, that kind of thing. So obviously, if that was to be leaked, that kind of information, you'd be in serious trouble. So again, if you get approached about jobs like that, without naming names or anything else, do seek top-up insurance cover to cover any eventualities like that. Also, if you've got high financial worth job, you're perhaps translating a contract that is going to mean there's another, I don't know, fleet of jets are bought by Saudi Arabia or something like that, and nobody actually knows much at the moment, but it's contract worth millions of pounds. Again, you need to go to your insurers and try and top up cover on that before you take it on. Bottom line really, though, is only to sign NDAs, non-disclosure agreements, that we're comfortable with, and we do need to read them, by the way. Back again to my big concern about many colleagues signing them and not even bothering to read them. Some are pretty straightforward, some are written in the most awful legalese that you actually need somebody to interpret for you, even if they're in your own first language. Some might be 1 or 2 pages. The worst ones that I've seen have been 40 pages. I don't know how they think we've got time to read all that stuff, but it's, if you're signing them and you don't know what they say, good luck to you. Not a good idea. We need to protect our websites in advance, obviously, as best we can. The HTTPS term denotes that our sites are encrypted and thus secure as far as they can be from hackers. See the small padlock on the address bar. Without the S, they're not secure. Encryption obviously scrambles data, so cyber crooks can't read it. Encryption gives us peace of mind. HTTPS stops online eavesdropping and unauthorized data collection. We're all prey to that almost every single minute, as far as I can see. And big plus, websites with an HTTPS prefix get preference ranking from Google. So bear that in mind. Also, in terms of protecting our online data in advance, we're all subject, of course, to malware and spyware threats, malicious software, which means that viruses try to steal personal information from us. They're snooping on our files, on our web activity. Solution, a pretty obvious one, really, and it's worth taking the time to do: install up-to-date antivirus tools. Another threat we're all subject to: phishing, scams, fake emails and websites designed to con us, usually into parting with money. I get masses of requests to interpret for widows who are coming over to the UK for treatment, and all that's required of me initially is to provide my bank details so that they can pay me a nice deposit, before they actually meet me in person. Get those about once a week. But the solution is, don't click on these emails, don't open them up, just delete. Type in web addresses and visit actual websites if you're unsure. Protecting all our data on all of our equipment, PC, smartphone, tablets, whatever you've got. Most of us have most of those. Avoiding public computers, public, access by the public, such as libraries, internet cafes, and so on. Checking that our home wireless networks are secure. Adding passcodes, non 1, 2, 3, 4, easy peasy type passcodes to our mobiles, to our cell phones. Trying to buy equipment which uses fingerprint recognitions. Using all the security tools and apps that are available to us. Some of them these days have actual scream alarms and remote locates and so on. Using all the encryption and firewall protection that we can get our hands on, basically. Storing files in the cloud, backing up files with external hard drives to try and counter theft and loss, and PC failure. I mean, that can happen to all of us, any of us at any time. But obviously bearing in mind that these external devices can be prone to theft as well. Solution may be cloud storage, files living online, cloud storage services I'm sure you're all aware of, Dropbox, Google, and so on, automatically are backing up files online, but of course they're not perfect either. No real easy answers. These are kind of best practice discussion scenarios if people don't have any specific questions. It's always wise to be prepared for that, but that's actually never happened to me. One of my bugbears as an interpreter is asking for advanced disclosure from courts about cases that I'm going to be interpreting for, and then being told, given what we call an old chestnut of an excuse, oh, we can't do that because that's confidential information, despite the fact that, we're about to go and interpret on that case in a day or week's time or whatever. But I always say in response to that kind of excuse, a good interpreter is a prepared interpreter. So, it's their lookout if we arrive on the day absolutely cold with little or no preparation under our belt. And then the bugbear that we've been talking about a lot in this presentation for translators, all the worry involved in subcontracting translation, or proofreading, whatever we're delegating, with or very commonly, unfortunately, without client's permission. Some resources for you. I'm sure these slides will be made available to you, so you can look at that in more detail later. I mentioned earlier about my business support sessions. Please do contact me for any one-to-one mentoring sessions on setting up and developing your business. And those are the kind of issues that we can look at: business cards, quotes, any of your standard documentation. Those are my fees. There are no cancellation fees, by the way. So please do get in touch. Those are my contact details, and I'm very much looking forward to hearing from you. Don't hesitate. And that's it. Thanks for listening. Any questions that you want to raise, if I can, I'll answer. Or don't have to be questions. There might just be comments or scenarios that you yourself have been involved in. Confidentiality affects all of us. Thank you for listening. Okay, over to you.
Thank you, Sue. Thank you so much. Let me get my video up so we show up on the screen together.
Oh.
Let me see how to do that. There. Okay. Listen, when you mentioned the 6.4 of the CIO regarding conflict of interest, it reminded me of a situation. I was hired, or contacted, I should say, to do a, what do you call that? A depot. So here I go for a deposition. Fine, I got contacted and I'm talking with them. And they sent me the material, and I look at the name of the deponent. It is a colleague, a friend of mine, somebody whose house I visit on a regular basis, have lunch, go to birthday parties. So I immediately contacted the company, and they let them know that there was this situation.
But I'm sure, Giovanna, you didn't reveal the name of the colleague.
Oh no, they the company's contacting me.
Oh yes.
So they knew, they had the information. So I told them, listen, the deponent is someone I am engaged with socially, somebody who is I consider to be a friend. So I'm not sure would be the best individual to do this job for you. If you have any concerns, let me know. And I had the names of a few colleagues to refer to them. So they said, thank you so much.
Oh, I see. Sorry. Yeah. Okay.
Yeah. So.
Yes, I see. Yeah. Because obviously jobs can be referred sometimes to us by agencies, or, you know, so they may have no idea at all of who they may have not even read the documents. They just contact us out of the blue and say, we've got this, we in the UK, we call deposition statements. You know, we've got this statement that we want translated. They probably haven't got a clue, you know, who the statement maker is, you know, even.
Right.
Or, you know, the job might be referred direct by the statement maker, but of course, if it was, they would know that they knew you. But yeah, interesting. But I think that was definitely the right course of action on your behalf.
Right. Jillian, what you can do is place your cursor on top of the image, and a few boxes will show up. You click on the one that looks like a window pane, and that should show all of us. Okay? Sorry, Jillian couldn't see you, only me. Oh. And the other thing is, you're talking about the ITI having a section dedicated to confidentiality, and the CIOL also. In the United States, we have the American Translators Association.
Yes.
And this is all they say with regard to confidentiality. I wrote it down.
Oh.
It's our responsibility or obligation as professionals to hold in confidence any privileged or confidential information entrusted to us in the course of our work. And that's it.
Yes, and I mean that is so tiny in terms of assistance for us, because where is the definition there of what is considered to be confidential information, for example? You know, who makes the decision about what's confidential and what's not? Because I've worked on projects both as an interpreter and as a translator where not all of the information, obviously, has been confidential. And I have been asked by the client to sign an NDA, a non-disclosure agreement, whereby I agree not to disclose any confidential information. But what I'm trying to put over here is that choice as to what's confidential seems to be left to me in some instances. I might get it right. I mean, obviously, if it's about the client's bank details or something like that, I would know not to reveal those. But what if I just happen to mention that, you know, to a colleague, oh, I've just interpreted in a job in London near Covent Garden, and the client was a French Canadian involved in the...
That's too much information.
You know, where do I stop, you know?
Yeah.
It's a bit murky.
Yeah, when I have a case that's especially trying, I do come home and I do let it out with my husband. But usually what I say to him is, there was this case today, and one of the individuals was really, really trying my patience. That's all he knows. He doesn't know if it was a man or a woman. And I am very glad I can explain this to him in English, a language that is kind of gender neutral, because in Brazil, if I say friend, I have to explain if it's a female or male by just one letter at the end of the word.
That's the same issue as I have in French. Yeah, absolutely. Yeah. That's
right.
interesting.
Yes, you can relate.
I hadn't thought of that. That's very interesting.
Yeah. So that's one of the things that allows me to be more free and talk about the work I do with my husband, specifically because the words allow me to hide the information I don't have to review. You know, was it a man or woman, doesn't matter. A child, doesn't matter. An individual. That's it.
But I think that's I'm really glad you brought that point up, Giovanna, because certainly in the UK, I know for us interpreters that we have been begging for a very long time for briefing and debriefing sessions where we're working on, you know, potentially traumatic or actually traumatic, you know, subject areas. Because when we come out, we literally have nowhere to go because mainly because of the confidentiality limitations on our work.
Yes.
You know, you can be, you want really very often to talk to a colleague because rather than the family members you've mentioned, because a colleague is more likely to understand. I mean, my own husband does work that's completely different to what I do, and you know, a colleague is much more likely to have been through a similar experience and to empathize and so on. But of course, even if I try and share experiences with a colleague in my language group, it's not beyond the bounds of possibility that interpreter has worked on the same case as me at some point. You know, I need only give a couple of details, and she or he might identify the client just on that.
Well, that's why I prefer to share with my husband, because he's completely disconnected from the type of work I do, and is not going to ask me follow-up questions. He's going to be sympathetic. Oh, sweetheart, that was awful. Is there anything I can do for you? Would you like a margarita? You know, but if I speak with a colleague, he or she may ask me questions regarding the case, you know, just out of compassion, just like they can empathize. We have a question from Jillian here. I usually ask my clients, I think it's a comment actually, about what is reasonable, how to use my subcontractors. Sometimes I've walked around the building and being asked what I'm doing by clients in other departments. And it is a confidential job, but they all know each other. Compartmentalize with clients and with colleagues. NDAs. I want to retain emails to prove that I did the work competently. Maximum to forward them back to myself without the attachments.
Yes.
Yeah. Well, I thank everyone for being here. It's coming on 2:30 already. So this was a great presentation. We have questions, we have comments. And we even had an engagement over on Twitter. There was a gentleman who had to leave and was very upset over it. His connection was awful.
Oh, that's a shame.
Yes. So I promised to send all the video to him immediately. So thank you, everyone. Sue, thank you very much.
And thank you, Giovanna, for your interesting contributions as well. And for inviting me, of course.
Well, you're most welcome. And we all have your contact information should we have any questions.
Oh, yes.
We all know how to reach you. Thank you so very much, everyone. Thank you for participating. Goodbye.
Bye-bye.
Bye-bye.